In this video, I'm going to just discuss pension adjustment orders in a divorce or judicial separation circumstance. It's important to understand at the outset, however, that a deed of separation between between spouses who have decided to separate and are not sure about what they're going to do in the future or haven't made up their mind yet, a deed of separation cannot make any changes to a pension scheme. The only place a pension scheme can be changed is by way of a pension adjustment order, which will be obtained in court. And the powers of the court in that regard are set out in the Family Law Act and the Family Law Divorce Act of 1996. Pension adjustment orders are another mechanism by which a court can try to ensure that proper provision is made for spouses and dependent children in a divorce. A pension can be viewed as an asset of either party and can be divided or transferred from one party to another. It's only available, the power to grant a pension adjustment order is only available after the granting of a decree of judicial separation or divorce. And as I said at the outset, a separation agreement cannot make any change to a pension. Any court application in respect of a pension adjustment order will require the trustees to be put on notice of it, and you draft up a draft pension adjustment order, you send it to the trustees, you give them notice of the intention, and you ask the trustees to confirm that that draft pension adjustment order is capable of implementation. And until you get the go-ahead from the trustees, until they confirm that it is in order, what you've drafted is in order, you will not get a pension adjustment order in court. So you need to get the trustees to approve your draft order, and you go from there. There's two broad types of pension schemes. There's an occupational pension scheme, a self-employed scheme. Occupational pension schemes then can be divided into two broad categories: defined contribution schemes and defined benefit schemes. The defined contribution scheme is one where an employee or employer would pay a percentage of the employee's salary into the scheme. This is then invested by the trustees, and self-employed schemes would generally fall into this category. Defined benefit scheme, on the other hand, is where a specific level of pension is supposed to be paid to the employee on retirement, usually a percentage of the employee's salary, and the civil service scheme would be an example of such a scheme. There's two aspects then to pension adjustment: earmarking and pension splitting. Earmarking means that a portion of the pension benefit should be paid to the other spouse. Pension splitting means that a percentage of the retirement benefit of a pension is used to provide a separate pension for the other spouse. This could be provided in the same pension scheme or in a separate one. And the pension adjustment order then, in respect of a retirement benefit, will specify two things at least: one, a period, and two, a percentage. The period is the period of reckonable service of the member prior to the divorce or judicial separation. This should state the commencement date and cessation date. And the percentage will be the percentage of the amount of the benefit to be paid to the other spouse on foot of the order. This can run from 0.0001% to 100%. There's no provision in Irish law for a nil order, so you must go through this motion of making an order for 0.001% to the other spouse, if that's what the parties have agreed, or if that's what the court orders. So remember, you will have two spouses, you'll have one of the spouses perhaps having a pension. The beneficiary of that pension will be the other spouse, and the whole idea of the pension adjustment order is to change that, given the changed circumstances between the spouses, the fact that they are getting divorced or judicially separated, and you might agree, or spouses might agree, to leave each other's pension alone, or the spouse who's going to benefit from the pension, not the member, may give up their right to any share in the member's pension as part of an agreement. And if that's the case, well then there'll be a pension adjustment order transferring 0.001% to the dependent or beneficiary spouse, in which case essentially the member spouse gets to hold on to the entire pension. When where an order is made regarding a retirement benefit, payment could commence immediately if the retirement benefit had already commenced being paid to the member spouse. In other words, that's where the member spouse had retired. Where the member spouse has not retired, payment of retirement benefit has not commenced, the applicant spouse has two options: to leave it in the pension scheme, and it will become payable when the member spouse retires, or the applicant spouse can have an amount of money transferred from the scheme which would equal the value of the designated benefit. Any applications to court in respect of a pension adjustment order or any other order regarding a pension obliges, as I said at the outset, notice to the trustees of the scheme. And once an order is made by court in respect of a pension, the order should be served on the trustees. One thing you need to watch out for is many lay litigants, many people will be able to sort out their own divorce. They may agree everything, and they may agree all of the big things anyway, and decide to do a DIY divorce themselves. That's fine, but they could run into difficulty when it comes to the pension adjustment orders, because they can be a complicated, complex area of divorce or marriage breakdown. And it's often the case, as I say, that lay litigants can manage to obtain a divorce without the aid of solicitors or barristers or anybody else, but they then will require legal advice and perhaps actuarial advice in order to get the subsequent pension adjustment order applications sorted out. So it's something you probably should consider. There is a bit of time involved in it. It involves going back to court, but it involves first getting approval from the trustees of the pension, and trustees that the pension adjustment order that you've drafted is capable of implementation. The judge will be looking for that letter in court when you bring, by way of notice of motion, your application to have a pension adjustment order made. That's assuming it hasn't been made on the day of the divorce. It is possible, if you're organised or your solicitor's organised, to have a divorce or a judicial decree plus the pension adjustment order made on the same day. But you do need to get all your ducks in a row. Hope you find this video useful. Pensions on separation and divorce, they are assets. They can be used as instruments by which a court can ensure proper provision for the spouse or spouses and dependents, and they're an important part of pensions, or an important part of a divorce, important part of a judicial separation. And to reiterate again, a separation agreement, a deed of separation between two parties, cannot upset or change a pension, because the trustees of the pension must approve it, must be on board, and then, and only then, can a court make an order to vary or change a pension by way of a pension adjustment order. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.